was unconstitutional or illegal, and they found that 4 times, they would have found some way to require us to come into compliance with the law or the Constitution. And so I'm very disappointed that our Ohio Supreme Court did not do that.
Justice Stratton?
Well, regretfully, both your question and answer reflect a profound misunderstanding of what the case was about. First of all, the case has not been pending for 6 years. Governor Strickland has promised to fix school funding, so we have no jurisdiction, no control over it. When we get a case alleging something is unconstitutional, our only responsibility is to say it is unconstitutional and return it to the legislature. Nowhere in the Constitution are we allowed to fix it. We are not allowed to give the solution. And it was very, very unusual for us to keep the school funding case under our jurisdiction, not because we were telling the legislature how to fix it, we just simply said, you must fix it. And on the 4th time, we did what we have done in every other case, dismissed it and expect the legislature to do its job. And if it didn't, then somebody has the right to bring a new lawsuit challenging its constitutionality. 90% of the case that was before us, if you actually read the briefs and read our opinions, was about buildings. That has been fixed. There is $1 million spent every single week on buildings. Everywhere I go across the state are new buildings. That was what the majority of the evidence was, and that is what the majority of the money has been spent on. So a lot of people will debate whether or not it's been fixed or not, but Governor Strickland is going to take the next step, and he's promised to do so.
Thank you, Justice Stratton. It's now the opportunity for me to ask one final question and for you to answer that question and also to provide whatever closing comments or statement that you would like. Each of you will have 3 minutes to do so. And I believe we begin first with, and I forgot, with Judge Sikora. Thank you. Judge Sikora, you'll go first. Last year, and this question involves the death penalty, the application of the death penalty here in Ohio. Last year, the American Bar Association released a report on the death penalty system in Ohio, and that report concluded that the death penalty system here failed to comply with national standards promulgated by the ABA to ensure that the death penalty process will produce fair and accurate results. The report found also, as part of its finding, that over the last few years, federal courts in post-conviction proceedings have overturned several convictions and death sentences previously affirmed through the Ohio courts and through the Ohio Supreme Court. The report suggested or concluded that, in part, these results were the product of case law and statutory decisions in Ohio that prevent a defendant in a death penalty case from obtaining all of the information necessary either to establish innocence or to defend the case. They gave an example, which is that public records that are available to citizens through a public records request to a police department or to a prosecutor's office couldn't be used in those post-conviction proceedings in Ohio. So the question I have is kind of 2 parts, and it's related to that report. Are you at all concerned with how the death penalty is applied and implemented here in the state of Ohio? And if so, what could you do as a member of the Supreme Court to remedy the alleged defects in the Ohio death penalty system?
That's a very complicated question, but a very good question, Dean. I appreciate the answer to opportunity to address it. Obviously, as a judge and as a candidate for the Ohio Supreme Court, I cannot give a personal opinion on the death penalty. We have a death penalty. The U.S. Supreme Court has ruled that it's constitutional, and states across the country have adopted a death penalty. We have a death penalty in Ohio. But it is very troubling when we hear reports showing that there are so many disparities in it and the concern that innocent people may be subjected to the death penalty. And there are a couple things that can be done to help restore confidence in the system and to make sure that we do not apply the death penalty in innocent cases. One of those, as you referenced, is open discovery. The Supreme Court has had the opportunity in the past to move towards open discovery so that prosecutors would be required to open up their files to give all the information to the defendants and not just the information that they feel is discoverable and appropriate for them to have. And we've seen time and time again where people, once the files are open, are exonerated. And that is absolutely tragic that somebody might spend years in prison, even on death row, when they are innocent, and it's because the prosecution has not divulged information that they should have. And another one that a law was passed back in 1995 encouraging the Supreme Court to adopt a rule that would require courts to report the ethnic background of individuals in sentencing, so that if somebody felt that their sentences were disparate because of their race, they would have an opportunity to challenge that. The Supreme Court has failed to adopt that rule, has failed to encourage courts to do it. Now, I've heard arguments that, well, it'd be too difficult, you can't force judges to do that, judges are supposed to be colorblind, and that's all absolutely true. My court has been doing it for years, and we do it simply by having the statistics taken at intake so that the judge doesn't have to worry about recording that kind of information. But both of those things, I think, can go a long way towards addressing any disparity in sentencing, and go a long way, I think, towards ensuring that innocent people are not convicted.
Thank you, Judge Sikora. Justice Stratton, please.
I understand this is also a closing argument?
Yes, this
Okay.
is 3 minutes to respond to the question and make whatever closing comments.
All right. The recent death penalty ABA study was unfortunately done by a very anti-death penalty group, so its premise was to try to do away with the death penalty. So you have to read it with that understanding and context. Nevertheless, our court took it very seriously. We spent literally a day and a half going over the death penalty. Our entire court came down for a special day of session to go over every principle in it that the court had some control over, and to set responses to the challenges raised in the report, and to see what we could do to make our system better. I still think we have a very, very good system. We provide two qualified public defenders for every single death case. We provide money for all of their expert witnesses, and we are very confident in the quality of our positions on the death penalty. But that does not mean that we cannot improve, and we are looking very hard at doing so, and we'll be coming up with several different proposals to try to address some of the issues raised in the report. So we do take that issue very, very seriously. In closing, I want to make one statement that is maybe not a traditional statement in a closing statement, but campaign trails, like I said, are the world's longest job interview. They can be very tiring and very difficult, and you're just never home night after night. You're in different parts of the state. You have 88 counties to campaign in. And about 3 weeks ago, I hit a low. Campaign fatigue, just kind of wearing out. And three things happened to me. One is my wonderful staff who's in the back sent me a big batch of flowers that just picked my spirits up. My husband gave me a good talking to about, how hard you worked and how you really need to get your spirits up and have a winning attitude, and you need to be on top of things. And then the third thing that happened is I went to the ONN debate. And here was my opponent, who sits in a wheelchair, who has a full-time job, who runs a statewide campaign. And I have never seen this man down or whining or discouraged or upset or complaining. He has always been the most cheerful person. He is a wonderful opponent to have. And I think he's a tremendous role model. And I just wanted to say thank you, and for giving me a lift in my spirits, because I couldn't possibly complain after I met him. So thank you again for all of you for listening to this debate and for coming to hear us. And we appreciate that you gave us a chance to share our thoughts with you.
Ladies and gentlemen, I think we are fortunate, as you can see today, that we have two very capable candidates, two experienced judges, people of great integrity. Justice Stratton, earlier, before we were commenting that this race has been very different from Supreme Court races just a few years ago when there was a great deal of antagonism, and I think these two candidates have represented the profession and the judiciary very well in terms of the way in which they both have campaigned. They've brought honor to themselves and to the lawyers here in the state of Ohio. So join me in thanking them.
Today at the City Club of Cleveland, we have been listening to a debate between Justice Evelyn Stratton and Judge Peter Sikora, candidates for the Ohio Supreme Court. Thank you, candidates. Thank you, Dean Mearns, and thank you, audience. This forum is now adjourned.